Hi, welcome back to the House Judiciary Committee this Thursday morning, May 29th. And we're going to have a walkthrough of the Senate amendment to S-109, which hopefully will be our last business of the session. So over to you, Eric.
Thank you. Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel here, as the chair said, to walk the committee through the Senate proposed amendment to S-109. You may recall this is the annual miscellaneous judiciary procedure bill. Senate sent a bill over here. Then this committee proposed an amendment, which added a number of sections, sent that back to the Senate. And now the Senate has proposed an amendment to your amendment. And you'll see when we look at it that essentially virtually nothing is added to the amendment, the Senate proposal amendment. Essentially, it involves striking sections that were in the House proposal. So very little new. I'll note what is new, but there isn't much at all. I should also point out that it was passed by the Senate just probably an hour and a half ago. And I just spoke with the Senate Secretary, and he thought it was being messaged to the House and should be there within 10, 15 minutes. So it should be in the House very shortly.
So we may be taking it up this afternoon.
Could be.
Taking it off the pending placement on those calendar. So.
All right.
Yeah, Ken, what was the vote?
It was unanimous. It was 5-0 in committee, and then voice vote unanimous on the Senate. Yeah.
Okay.
Chair, how is it going to be reported? Is it just Barbara, or is it going to be everybody?
But just be Barbara.
Okay, just for us hearing these changes.
Yeah. Yeah. Won't have to say a lot about this one being taken off, that one being taken off, this one being taken off. So,
Here's what we lost.
All right, so the document you should have is a document that is entitled Senate Changes to House Amendment. You have that one? So it's highlighted in yellow at the top. So highlighted in yellow are all the changes that the Senate has proposed, and they start, I believe, on page 17. So this is the Firearm Surrender Order Compliance Working Group. You remember that what happened over here in the House was that originally it was a lengthy list of members of the working group that came over from the Senate. Then what the House did was it removed some of those members from the actual task force, or the working group, I should say, and created a list of consultees. So what the Senate did, you see bottom of page 17 over onto page 18. The House version had taken two entities, the Center for Crime Victim Services and the Council on Domestic Violence, and moved them from the membership to the consultees, and the Senate moved them back. So they want the Center for Crime Victim Services and the Council on Domestic Violence to be members of the working group rather than consultees. So that's the proposed there.
Sure. Just for the sake of the format of the discussion, can this be interactive with Eric as we're going through this?
Yeah, just to raise your hand.
Okay. So
yeah.
But Eric, just to have it on the record, nothing was removed from the member group to the consultation. It was only from consultation to the membership.
Exactly.
Okay.
Exactly. Yep. So I think that was the only proposed change to that working group. And then we move on to page 22. And this is these are sections 27, 28, lines 7 through 13 on page 22. And this is, you recall, the removal of the sunset on the increase in marriage license fees. And they struck that, but that's just because it's already been signed. It was in the big bill, it was signed by the governor. So that's already law. No reason to have it twice. So that's out. Also out is the next section. You'll see this is a provision that provided for appeals of bail revocations by the prosecution in the same manner that other appeals are provided for now to a single justice of the Supreme Court. This was a timeliness issue in the sense that the Senate Judiciary Committee felt that the time within which they had to look at this section would involve taking testimony from the prosecution, the defense, the court, and as it happens, as people in here probably know, the Senate morning committees stopped meeting earlier than other committees do, and they didn't have time. So they said it wasn't that they didn't think maybe it would be a good idea for next year, but they just felt like we don't have time to look into it right now.
One other clarifying question, because I know that in this room, within this committee, it's customary for the miscellaneous to come out unanimous. Is that also true of Senate Judiciary? So all the strikeouts were arrived at unanimously?
They were all arrived at unanimously, but the broader question that you asked, which is that would they ever pass a miscellaneous bill that could conceivably not be unanimous? I haven't heard them express that as explicitly as you guys have in this committee, so I don't want to speak for them. But I can say in this case that everybody was on board.
Okay,
Yeah,
That's
exactly.
what I'm looking for.
Yeah, sure.
So just to be clear, I think it's more the opposite, that if there's any objection to something being in, they would take it out, as opposed to unanimous that they wanted to take something out. I mean, it's a little bit different. I mean, so.
I understand, yeah, I understand what you're saying. Yeah, slightly nuanced.
Yeah.
So on this section, just to clarify for my own sake, Senate Judiciary felt like they didn't have enough time to take testimony to clarify what is arguably something they already have a right to do, which is appeal bail revocation question.
Actually, that's a fair, thanks for refreshing my recollection. They also made that point, which is that arguably it's permitted already.
Great. Well, we clarified that it was permitted, but all right. Well, yeah.
Thank you for the clarification. Thank you for the clarification. Excellent, thank you.
Is that clear? All right, so that section is out, proposed to be out. Victim notification task force still in, earned time reduction program still in. May recall those came over from the House Corrections Institutions Committee. Those are unchanged.
I did notice that everything that came over from corrections is still in, and stuff that we worked on is not, just so. So apparently the dean of the house has more influence downstairs.
Yes.
Anyway, go ahead.
Another working group that was removed starts on page 28. This is the Adult Involuntary Guardianship Working Group. Remember, this was the idea that should the probate court and other interested parties be looking at whether the current system, which involves adult guardianships being sometimes heard in the probate division and sometimes heard in the family division, depending on whether it's an adult with disabilities, should that be continued or should it be consolidated into one proceeding? I think the concern again down there was, is there time enough to talk to the interested parties about this? And also, I think they also, which you'll hear me say a couple of times, which is that they felt that a study committee or working group wasn't really necessary in the sense that those parties could make a recommendation if they wanted to without having a statutorily required working group.
Again, Don would be able to be, sorry.
Right, yeah, okay. So, yeah, exactly.
This was, to be clear, this was the working group that Larry was in her advocating.
No,
This was not.
That
Okay.
was later, which also.
It also got moved.
Yeah.
Okay.
There. Yeah. So I will be putting in, but don't worry about a bill drafting request that has that exactly. I will email you.
This one, section 32,
Yeah, yeah.
you could possibly, I haven't heard, might be draft request 1. If you want.
Wow.
Yeah.
Yeah, so let's call it that.
All right.
That's nice.
I can't, I'm not responsible for numbering.
Oh,
I haven't heard of any others yet, so.
Yeah.
Shall I put that in?
yeah, please.
All right, so that was section 32, section 33. 33, you may recall, was also from House Correction Institutions. This was involving the issue of having the assistant judge request for capital funds for county courthouses, adding some criteria that have to be considered by the court administrator when they make a recommendation about those requests. However, there was a portion of that was struck, which is over on page 33, a related portion. You may recall, excuse me. Sorry. This provision that I just described, the new criteria that the court administrator considers when they're making a recommendation, that has a delayed effective date. So it's July 1st, 2026, you may recall that. And in the interim, there was meant to be a report, which you'll see on page 33. And during that interim, the president of the Association of Assistant Judges and the court administrator were going to report back on how they were getting up to speed on these new criteria. Similar to what I just said, down in the Senate, they felt that this could be done without a formalized statutory report. You could get some feedback back from them. They could provide whatever feedback they want to provide, and you could still take testimony if you want. If you feel that going forward, it's something that you need to look at legislatively, but they didn't think it needed to be formalized in statute.
So one thing from corrections was dinged after all. So, yeah, I guess I overemphasized the. Yes,
I guess since corrections is in the room, you're comfortable with this change?
For the record, Alice Evans, Chair, House Corrections and Institutions. I would feel more comfortable with the language being in there to make sure that the side judges did work together. and
Right.
get along. That was one of their concerns, that they really do want time to work. And with the proposed language to make sure that everyone's on board, we wanted to make sure that they did do the work. And they came back to us. So that's why we put in the language. That's also why we had an effective date, July 1st, 26, to allow that. So we can set a little.
so can you send a letter of kind of make it a little more official?
We could do that.
Yeah.
So that was when they testified to us. They said we would really like to have some time so all the side judges could weigh in on this proposed change. And that's what we want to report back to make sure they do.
And I think, like, just from my own personal perspective, anytime that the reporting is introduced in legislation, it is that accountability mechanism that I think we often discuss in this room is could be lacking potentially, which I think is why it is critical. So I guess maybe I have some concerns on that.
So I probably missed this. Are you okay with it?
I'm okay. I mean, at this stage of the game, we can do it, and your chair suggested that our committee just write a letter to the side judges with our intent that they report back to us in January.
And do they listen to your letter? I mean,
We hope so. This would be legislative intent.
that does have some power.
Yeah.
Okay, thank you.
Yeah, and to change anything on this other than concurring is taking a big risk and this dies.
Okay, so. Yes, thank you. So the next change, actually, it's connected to a section that wasn't changed. So this involves two sections, bottom of page 33, top of page 34, sections 35 and 36. Remember, this is the one where the number of hours of community service for a second DUI, minimum hours, I should say, was reduced from 200 to 80. So it's when, there's still this, I think it's a 2 years, 20 years maximum felony imprisonment. That stays the same, but this statutory language that exists now that says, well, of that sentence that's served, at least 200 has to be of community service or 60 consecutive hours in incarceration. And so they kept the proposal that this committee had, which is to lower the number from 200 to 80. But you may recall that when it came out of the House, it had a 3-year sunset. So it was 3 years and then check back in and see how it's going. Their thought on that was similar. Again, as I say, it's a recurring theme. If it's not working, you can always revisit it and change it at that time. Rather than have the sometimes tricky mechanism of a sunset, you don't lose sight of it, that sort of thing. Right. So that's why they struck that. Another struck provision 37, you'll see is the family forensic evaluator recommendations. Again, this was the Chief Superior Judge, Director of OPR, and ED of Vermont Psychological Association, making recommendations about how to expand the use of family forensic evaluators, similar to what I have said and will continue to say. They felt that that could be done without the statutory mandate requiring that these people engage in this process.
Okay.
All right.
And second to lastly, in terms of the sections that are removed, is the Child and Parent Legal Representation Task Force. That was section 38. You may recall that was the task force that was studying legal representation for children and families involved in CHINs and substantiations of abuse and neglect proceedings. That one was one where, and this kind of goes to your question, that there was, I don't know if I would say not unanimity, but there was certainly disagreement over whether or not this was something that should be included or not. And I think they felt that they could look at this again, and they were again open to looking at it again, but they didn't feel like with the level of disagreement, which there was, that it was appropriate just to include it with all these others, hopefully unanimous provisions in the miscellaneous bill.
And I guess, and so a clarifying question to the chair, this is, you're gonna propose legislation that would address this separately?
So we have a bill 193 that this came from.
Right.
I could still be the vehicle for.
Okay.
So, yeah.
I just think, I think, not to opine on this too much, but it's a little bit discouraging in the sense that we had such really powerful testimony that we received on this and really well thought out, deliberate witnesses that are very passionate advocates for the work that this, work group was going to do. And I think also a lot of compromise within the committee of removing different things and adding things back in to get us to a place where we could find consensus. So I just want to express some disappointment there because I really do think it was going to be some great work. And Larry was obviously a very thoughtful advocate for this piece. But grateful that it will go into another vehicle and may accomplish.
I did express that offline to just those thoughts to the Senate Judiciary folks, but they just didn't have, it was in part also time because
Right.
it took us a while to hear that testimony because early on in that process, I wasn't fully
I
on
agree.
board with it. But through quite a bit of testimony, they brought me along, certainly, I think everybody else here, and they just didn't have time to do all that, so.
Which I understand. Yeah.
So, April.
And I will share Zach's, Representative Harvey's disappointment and say that I think there is another potential path to this work being undertaken or continued, even without this and maybe even with 93 that I think that the various stakeholders are in conversation, hoping that work will continue and that its removal from the bill doesn't necessarily equal a cessation of the activity.
Yeah, no, I think I've heard that from Larry as well, so. All right.
Well, I will share my disappointment. And I will not be candid. So I will just say I'm just very disappointed. When a chief member of our government rarely participates in witnessing before committees, comes before us collectively, regardless of the two houses, and shares the level of concern and interest that he did. That says a lot. So that being said, just disappointed. I'm gonna leave it at that, because anything else would be totally out of character for me.
All right, so, and let's move on to the good news that we were able to accommodate corrections.
Yes, I think the version you're looking at, the sections aren't numbered because this was done late, but so the next sections that you see are sections 31 through 34 of the bill that just passed the Senate this morning. They start with, and so this is an addition, not a subtraction. And this is the family support program within the Department of Corrections that was actually vetoed earlier this session in H 219. Remember, that was vetoed by the governor because at the time the language included a requirement that the Department of Corrections proposed sufficient funding in its budget proposal to support the program. And the governor's perspective on that was an unconstitutional separation of powers violation, intrusion on the executive authority with respect to proposing budgets. So the language that was concerning to the governor's office was removed. And I emailed with the governor's council as well as the Department of Corrections, and they are okay with this language as is. They feel that this removes the separation of powers problematic language. So it was put back in because I think in fact the governor indicated in his veto message that his problem wasn't with the policy. Policy was fine. It was the separation of powers issue.
Yeah.
So so that was removed, and so now you have essentially, other than that, the same language that was in H 219 that already passed earlier in the session, which goes to support this program within the correction facilities to assist incarcerated parents and guardians with their families and free parenting concerns.
Just a quick question on this, Eric, and
Yeah.
I appreciate the clarification on the administration's stance on this.
Right.
And you have to forgive me because now we're going back to a bill that I don't necessarily recall. It's just a little bit of a refresher.
Yeah.
But insofar as you're aware, I guess as included in S-109,
Right.
are there appropriation considerations and are monies allocated? I'm sure that might go to the chair of corrections.
If you don't know.
Well, what I understood is that the funding for it is already covered within the Department of Corrections general appropriation. So that, yes, it will require some funding, but that
It's already covered.
it's already covered for. Exactly.
That's all.
Yeah. Did I get that right? All right. Yeah.
Say that again?
390,000.
Oh, we're getting that budget. Okay.
Let me go into what.
So,
And it's for the men's.
It's 390,000 for FY 26. A portion of that is to make whole the program that's at the Chittenden facility for women. We had Department of Corrections working with Kids Apart in Lundholm over last summer and fall to come back with a proposal in terms of how to expand this family support system, which is really working with the incarcerated person to keep contact with their children. It's been effective, it's been working in the Chittenden facility for 20 years, and the thinking is we need to expand this to also the other facilities that for male incarcerated folks, the dads. DOC and Kids Park came back with a recommendation to expand it to the other facilities. The first one that's going to participate will be Newport. And that also was about, I believe, around 200,000 to carry that out. So the 390,000 was to make whole what's happening at the Chittenden facility and then to start the program for Newport. The goal of H219 is to expand it to all facilities regardless of gender for parity. And that's the goal. And we have also codified that program because it has not been in statute before. So we have also codified that in the bill that H219 it's vetoed, but it is now in S109.
that's cool.
So that raises an interesting question, which is all Vermont facilities, or are we requiring it of our out of state?
The out-of-state one is really difficult because that's down in Mississippi.
I know,
And you can do that virtually.
right?
We would not be able to do it one-on-one, so that would have to be
Yeah.
dealt with in a little different.
But it's not explicit in the bill itself. Right.
And I guess just another quick follow-up, Chair Evans, about the language as included in S-109. This represents a scaled back version of what 219 sought to accomplish.
No,
This is the full scope of the program.
it's the full bill. The difference is we had language, and this is what legal counsel of the administration said was unconstitutional. Though our legal counsel said it was constitutional. It asked DOC when they submit their proposed budget in the fall to the governor, they would include funding for this program. It did not lock in the governor to put it in the governor's budget that they proposed to us in January. That was the piece that was deemed unconstitutional. So we took out that language, we put in what the administration suggested, which I'm not sure which section it is, but it's really the second section of the bill that the Commissioner of DOC would provide and sustain trauma-informed family support services and program pursuant to the section of statute that codifies the program. And I met with legal counsel of the administration, along with our legal counsel, Ben Novoprosky, Jay Johnson, and she agreed to the language, agreed to the bill, and we shook hands. So there was a handshake on this.
Okay, thank you.
I'm a little old fashioned, but there's a handshake.
I appreciate it.
Angela.
So fully aware that we're not really going to be suggesting changes to this language. But I do notice that on page 5, page 38, line 5. It says the DOC shall establish family support programs to provide free parenting and family support at each correctional facility. It's not free. It's free to the parents. It's just I don't know if that can be,
I'm not looking at you.
yeah,
I mean, what line, what section?
it's gonna cost someone something. Free parenting and family support, it's section, it doesn't have a second number.
That's the intent, but DOC would include this in their budget.
Yeah, I'm just saying.
Yeah, but I think it could be interpreted as free to the parents.
It says,
Well,
if you keep-
it's intended.
if you
but
keep
it's-
reading, it says to all incarcerated individuals who are parents or guardians. or
Right.
offender, so free to.
Right.
No, the services are provided to. But anyway, support is provided to, it's not free to, it's support to. The free is.
I had a
Anyway,
lot of clarity earlier.
yeah, it's just obviously, we're not changing it, but it's like, could it be interpreted that it shouldn't cost anyone anything?
I guess I don't agree with that one. but-
Well, no, probably no one else will.
That's just how-
But if you're getting all the way down to like what you're actually saying.
But we can't mandate a private agency to do something for free.
So,
Right,
Nothing
but
to be done
since,
on that, I think,
since the question is like getting, wanting this to be included in someone's budget, it's just.
Yeah.
Of note that we're saying it's actually free.
To the DOC.
Got the best for two?
All right, so. Any other questions? Yeah, well.
Not a question. I'm very supportive of putting this in to the miscellaneous bill. Great.
Take a motion to find favorable the Senate changes to the House amendment on S-109. Second. All those in favor of finding it or finding it favorable? Or concurring, I should say, to the Senate changes House. And those opposed? So 8-1-2. And Barbara, you're gonna be ready this afternoon to take this?
I am ready.
All right, and you can always yield to you if there are questions on that last section that Barbara can't handle herself, which I'm sure you probably could all think. You ran and run for a long time.
I agree, I'll make that.
Review my digital aid.
Yes, Mr. Chair, that, just for the record, that was my only negative vote.
I understand.
Agree by any.
Yep, well. I appreciate that, and thank you. If this is our last meeting, thank you everybody for the session, and have an excellent summer, although I'm sure we'll be in here twiddling our thumbs a bit over the next 6 hours.
Do a tour.
Yeah, and maybe still try to set up that tour of the dome if anybody's interested. We can try to do that.
Who do we
Yeah,
try?
Yeah.
Kenny's